So thanks everyone for joining us for what I know is going to be a really excellent session. We absolutely encourage some questions and interaction, so please feel free to use the chat bot to type in your questions. And if you want, you can also use the raise your hand option, and we can call on you for real-time questions. But I know this is going to be a really great session, and I'm so thankful for Kate and Anthony for suggesting this. We've had a lot of discussions with Anthony in the past about PPP and some other opportunities regarding, what do we do now? What's kind of the current situation? So this seemed like a really great time to say, okay, what's next, right? We have the opportunities. We're going to be going back to the office, potentially, a lot of people. Are we, aren't we? How do we do that? What are the options? And what kind of things do you need to know as people who run a business? So I'm going to take this time to turn it over to Anthony and Kate. I will just remind everyone, if you are not speaking, keep yourself on mute so that way we don't have any background noise. But we'll be doing Q&A at the end, or if you have real-time questions as they're chatting, please put them in the chat bot. And everyone, we will be recording the session for future use. So feel free to listen up and not feel like you have to write down everything and take notes. We'll make sure you get a copy of everything. So I will turn it over to Anthony and Kate.
Thank you, Rachel, and it's great to be back with MassMEDIC. As Rachel said, we did a couple of these early on as the CARES Act was moving through Congress, and we were trying to sort of get our arms around what benefits would be available to all kinds of businesses, but certainly those in the medical device community. And as those policies became law and became subject to regulation and interpretation by the agencies that would carry them out, it sort of moved out of my wheelhouse of political hackery and into the wheelhouse of my very, very esteemed colleagues in the law firm. So I'm pleased to introduce to all of you Kate Beatty from MINTS's Employment, Labor, and Benefits practice, who's going to be walking you through all sorts of thought leadership, I guess, that she and her colleagues have put together. Things that they've been thinking about, considerations that need to be made, and I'm sure a lot of you are thinking about it too, and we're happy to be a resource. I'm sure many of you are familiar with the life science works that MINTS does as a law firm, but the ELB practice is really a leader among our peer law firms. So it's a great privilege to have a partner with us today in Kate. But to begin, I'll just go through very briefly what is moving in Congress, because it's important to the discussion. And as you know, we went through the CARES Act, which authorized the Paycheck Protection Program. And then we did a sort of an interim bill, which plussed up the Paycheck Protection Program by $300 billion. Well, now we're looking at a sort of they're calling it a technical fix bill. And the Paycheck Protection Program Flexibility Act passed the House last week, and it has not yet passed the Senate because there are a couple of hangups in the language. But I'll just go through basically what it does, with the caveat that there are some sticking points, and we'll see how they get resolved before the Senate passes it. But just for your edification, this bill passed the House almost unanimously. There was one no vote. So it's a very bipartisan effort to sort of tweak some of the requirements, particularly for forgiveness. So the non-controversial part extends that 8-week window you're all familiar with to 24 weeks, or the end of the year, whichever comes first. The Senate bill that was initially being considered extended it to 16 weeks, but it seems like everybody's accepting of the 24. Regardless, I think by the end of this week, you're going to see that 8-week window change, probably to 24. It also pushed back that deadline to restore full staffing and headcount, and the wage levels. As any borrower knows, that was required to be done by the end of this month. the bill that passed the House and is being considered in the Senate pushes that back to the end of the year. It also extends the application deadline because there is still money left in the pot from, again, the end of this month to the end of this year. And this was an issue that came up a lot, and it came up in previous webinars here. What if you're unable to rehire employees who've been laid off or furloughed, or I guess I should say laid off? And basically the best we had at the time was SBA guidance that said, well, if you can document that you made an offer and the offer was declined, then you're not going to be held, you know, you're going to be held harmless for not being able to get those employees back on payroll. Well, the bill actually codifies that. So it makes very clear that if a business can document that they made their best effort to rehire those employees or to find qualified replacements and were unable to, they're still eligible for forgiveness and it doesn't count against them. A key part of this, and this is, you know, not to get too deep into the weeds, this is really the hang up. The bill moves that 75-25 ratio of payroll to other expenses to 60-40. So as you might recall, after the CARES Act passed, the Treasury Department decided that 75% of all PPP loans has to be used for payroll expenses, and the other 25% can be used for utilities and rent and mortgage interest. For high overhead businesses, I suspect, like many on the phone today, that just became sort of an unworkable ratio. So the House bill, like I said, moves that from 75-25 to 60-40. The hang up is the way the House bill is written, it creates a cliff at 60%, which is to say, if you spend 59% of your loan on payroll and 41% on other expenses, you're not eligible for any forgiveness at all, which is not the intention. And really that's what the Senate is trying to resolve right now. So that's the only reason this hasn't flown through the Senate. They're trying to fix that. But I think everyone is in agreement that 75-25 had to move. The Flexibility Act also allows businesses that received a PPP loan and forgiveness for it to defer the employer share of payroll tax payments, which was supposed to, was specifically a benefit not intended in the CARES Act for those who receive PPP loans, but this is a reversal of that. So if you do have a PPP loan and you haven't been holding back that payroll tax, if and when this passes, you'll be able to avail yourself of that benefit. It extends the deferral period, which was initially 6 months, to at least until the SBA makes their payments on forgiveness. And for new loans, this wouldn't apply to any loan that's already been made, but for new PPP loans, it establishes a new maturity period. It was 2 years, it's now going to be 5. It also specifically says in the bill that any loans that have already been made can be renegotiated between the lender and the borrower. If the bank agrees to give you more time than 2 years to pay back any non-forgiven part of the loan, then nothing in the statute says they can't do that. But for new loans, if you haven't got a PPP loan yet, you're eligible and you want to go, the maturity period will be 5 years. But the key things are that 8-week window and the staffing and wage deadline and that 75-25 split. And again, it's working its way through the Senate right now and trying to get fixed. But the last we heard, and I spoke with the Small Business Committee yesterday, is they're looking at this week. So hopefully we'll have a firm report to give you no later than Friday. And with that, I will turn it over to Kate to talk some technical. Thank you very much.
Thanks, Anthony. That sounded technical to me. So thank you for your insight, and thank you to Rachel and MassMEDIC for hosting us. As Anthony mentioned, the employment group at Mintz has been counseling clients every day from the start of this pandemic and even before on all of the issues we'll talk about today, all the issues that have been probably keeping all of you up at night, whether it be the early stages of travel restrictions to then furloughing and laying off employees, applying for PPP, and dealing with the medical issues, the leave of absence issues, and now thinking about what does the workplace look like over the next 3, 6, 9, 12 months. And just to give you some perspective, Mintz, our ELB blog, our employment blog, has been continually churning out a lot of COVID-19 guidance and thought leadership. And just over 4 months ago, January 28th, was our first blog post addressing COVID-19. And to give a sense of where we've come in 4 months, what we were discussing in that blog post was the fact that coronavirus seemed to be maybe coming to the US and advising employers on banning international travel and travel to the then hotspots. So it's amazing to think of where we are now in just these 4 months. So I have a great deal of content to cover today. Each one of these topics really could be a standalone hour or more program. So we're going to try to get through as much as we can. I'm happy to answer questions. And this is really for all of you, trying to help issue spot and give you food for thought as you work through all of these issues. And I know from talking with Anthony and Rachel that many of your businesses have stayed open throughout this. So that's another unique challenge in that your operations have certainly been altered, but maybe not as much as some that have been totally shut down. But that brings its own unique challenges as you try to get to this new normal. So just touching quickly on the PPP forgiveness, and Anthony touched on some of these points in terms of what's in the new proposed legislation. But as a quick overview on the loan forgiveness, which I know a lot of clients are now focusing on the forgiveness piece of this, there is the form 3508, the loan forgiveness application. It has 4 components that are set out here. Importantly, and we're getting a lot of questions on the forgivable costs, of course, being payroll costs, business mortgage interest payments, business rent or lease payments, utility payments. Forgiveness is generally available for costs incurred during the quote unquote covered period, which is another issue being addressed in the new legislation that Anthony referenced. But that's right now it's that 8-week period, and at the current ratio is the 75%, hopefully going down to 60. But it's important to remember about the documentation and some of these key considerations. So be mindful of retaining documents that might be required in terms of the backup for your loan forgiveness application. With respect to the costs, they must be paid or incurred during this either 8-week or however the extended week period is for this covered period. So we've had clients with questions about the impracticality of trying to figure out a partial month, what the water bill could be allocated to half the month. That's why this has the paid or incurred. So as long as you're either paying the cost during the period or you incurred it, right? It was on the meter during this covered period, then that's going to be eligible for forgiveness. So there is a bit of cushion or wiggle room there. And then payroll costs include the employer's contributions for health insurance, retirement plans, and state and local taxes, but again is limited to the amounts paid during that covered period.
Hey, Kate, before you move on,
Sure.
question from the audience. Have utilities been specifically defined?
It's a great question that I frankly don't know the answer to. Anthony, do you know if it's actually in the
It's not in the
reg?
statute.
Yeah.
Yeah, it's not in the statute. I'd have to look at the interim final rule again. I'm not sure, but that's something
Okay.
we can figure out.
Okay, great.
So we've already been stumped, so we can only go up from here.
That's awesome.
Okay, so with respect to returning to the office, and there's been a great deal of guidance both on the federal level and on the state level and even the local level. And even though this is what I do for a living, I can find it overwhelming. So I can only imagine for business management and business owners trying to actually run a business, how overwhelming all of the different guidance that largely is overlapping, but maddeningly not always so. So I've tried to break this down for you all here and give you some of the kind of the key considerations and key checklists that you should be thinking through as you either reopen the office or bring more employees back to the office and to your manufacturing facilities. So here in Massachusetts, we're now in this 4-phase approach that the governor has set forth. They've issued the reopening plan. Each phase tentatively to last 3 weeks or more, depending on where the COVID-19 numbers go. The Massachusetts COVID-19 website has a great deal of guidance for employers. There's sector-specific guidance, including offices. But generally, to reopen, each business must follow the Massachusetts mandatory safety standards for workplaces, and I'll break those down shortly. Develop and maintain a COVID-19 control plan, which attests to compliance with the safety standards, and then print, sign, and post compliance posters. So all of this is available on the state's website. It's relatively user-friendly, though there's certainly a lot of information to navigate, but it's certainly a site that you should be frequently checking. So in terms of the safety standards and that Massachusetts has set, and these are consistent with what both the CDC and OSHA, the Occupational Safety and Health Administration, have set forth, and hopefully what you've already been doing and what has been in place for some time. So social distancing, maintaining that 6-foot distancing in the workplace, posting social distancing signage, requiring face coverings. At this point, if you haven't already, it's good to be thinking through ordering the amount, enough PPE, including face masks or gloves, depending on the workplace, thinking through the flow of traffic in whether it be your elevators, your office buildings or warehouse buildings, whatever it may be, really just kind of actually taking the paces through these workspaces and altering and trying to create a different traffic flow, including thinking about closing your kitchens or closing the kitchens during high traffic time, thinking about your conference room space. These are all really kind of practical solutions that have to be tailored to your particular workspace. Hygiene protocols, making sure that there's that hand washing capability throughout the workplace, having the disinfectants available, hand sanitizers available. With respect to staffing and operations, there's a lot of talk in Massachusetts about training employees, and I'll touch upon this a little bit later. And I think, and I get the sense from clients that there's a certain amount of social distancing and hygiene fatigue in terms of both with respect to people just being tired of wearing masks and social distancing, and also with respect to now that we're thankfully in the past the surge, potentially a feeling like it's not as important. The state is very clear that they need employers to maintain the vigilance with respect to training employees on social distancing and hygiene protocols. And I'll touch upon this later in another slide, thinking through workplace staffing. And there are, again, some specific guidelines, for example, for offices in terms of your capacity as you come back, with all of this being somewhat fluid, of course, and then cleaning and disinfecting. There are certainly private companies that are providing these services and have specific COVID-19 protocols that they're following, and more entering the market kind of on a daily basis. So as I said, the CDC and OSHA, which are federal agencies, have also released and keep releasing guidance. So it's certainly important to keep up with the CDC and OSHA websites. One question we get from clients with respect to what they tell employees as to what guidelines they're following. We typically recommend that employers just refer to the federal and state guidelines and direct employees to these sites and say, these are what we're following, right? So that because they're being updated so quickly, and something that was the recommendation 2 weeks ago might be different today. So rather than having something set in stone with your workforce, having the CDC and the state guidelines be a touchstone, I think will be more efficient and more workable for you as you bring folks back. OSHA has also issued guidance on administrative and engineering controls that might be appropriate for employers to put in place, and they've categorized them based on the level of risk of an employee, whether it be the workplace that they're in. So for example, in a call center or a manufacturing facility, there might be less ability to social distance. Certain types of businesses, of course, have employees more on the front line in terms of exposure to coronavirus risks. And then this last bullet point is important to keep in mind. OSHA has just recently decided and issued guidance that the agency considers COVID-19 a quote-unquote recordable illness. So employers should record work-related COVID-19 cases. And what work-related means is not an obvious definition. The OSHA has issued guidance that employers should conduct an inquiry to determine if the case was quote-unquote work-related using the readily available information that you have, but without conducting, and there's no need, and you actually shouldn't conduct an extensive medical investigation. But for example, if there was a cluster of COVID positives in your workforce, or if someone came in touch with a third party like a customer or a business partner or supplier that then tested positive and they had been in close contact with them in their capacity as an employee of your company, then that would arguably be a work-related COVID-19 case and should be logged in case there's further action or an OSHA action with respect to that case. Along the lines of the Massachusetts guidance in terms of having a COVID-19 response, and this a response plan set up, and this also flows into the concept of keeping your employees informed regularly and with a measured cadence and measured tone. We've recommended our clients designate a COVID-19 officer or a task force. Really the idea, depending on your management structure and your staffing capacity, it could be someone in operations, it could be someone in HR, but it should be a central point of contact, whether it be an individual or a task force that all the COVID-19 decisions and controls and communications are coming out of that task force or that officer, so that you have a consistent approach with respect to how you're implementing your COVID-19 response plan and the policies and practices that flow from that. Of course, if it's a task force, best to have it be multidisciplinary depending on your business operations. So having representatives from operations, human resources, IT, facilities management, legal, should you have in-house counsel. And this way, this group are the ones that have the lucky task of keeping up with applicable CDC, EEOC, OSHA, state guidance, and you're giving consistent feedback and direction to the workforce. So as I mentioned, what we've seen the most effective for employers in navigating this pandemic is, and conversely where we've seen hiccups with workforces, is employee communication. So this is such an exceedingly difficult time for both employers and employees. So many people are working remotely. There's not your usual camaraderie and ability to walk into someone's office and check on their well-being. So we have been stressing that employers should be focused on issue spotting and preparing for how they're going to communicate with employees, building on communications, keeping the lines of communication open, such as conference calls, town halls, newsletters, or regular email communication, even if it's just to say, we don't have much new to report today or this week, but keep doing what you're doing. Or even if it's more morale boosting communications. So there's a mix of information, policy, reminders, and just a touch point for your employees. Another important component here is that, particularly with workers working remotely and then coming back in spurts or phases or in staggered schedules, the normal ability for an employee to raise a concern or a complaint is hindered. And I was actually talking to a client the other day who made the good point that from an HR or operations perspective, normally if someone, for example, is out of the office for a couple days in a row, their manager and their HR is on notice that something might be going on with them, right? And that maybe someone should check in with them, see if they need a reference to EAP, or they need a leave of absence or STD information in terms of benefits. But here, where we're all working remotely and so many people are working remotely, we don't have those natural workplace cues that we would have had a couple months ago. So making sure that employees feel comfortable and understand how to raise complaints or concerns, who they should be raising them to, whether it be to their manager or to HR or to the COVID-19 officer or task force. And as we bring folks back into the workplace, there are going to be new policies and procedures and trainings. So it's important to make sure employees understand how they can avail themselves of those trainings and resources. Okay, so lawyers, especially employment lawyers, love to talk about policies and protocols. So, what I tell clients and employers is there are certain bare minimum policies you should have in place, but you always want to make sure if you put a policy in place that you're complying with it yourself, right? So pulling a sample policy off the internet and then putting it in a drawer and not actually following it and complying with it is worse than not having a policy at all, oftentimes. So thinking through what you realistically have the bandwidth and capacity to put in writing, or if it's not a formal policy, having a protocol that your managers or your operations or HR team understand that this is the consistent approach that you'll be taking with respect to certain issues are really important. So again, with this COVID task force or COVID officer having an infectious disease preparedness and response plan, which the state of Massachusetts has samples and certainly is encouraging employers to have. Setting or updating policies on workplace conduct and teleworking conduct to address employees who continue to work remotely. So for example, hopefully it should be intuitive, but employees should be reminded that non-discrimination, non-harassment policies apply as equally to a teleworking situation as they do to the workplace. So sending someone inappropriate texts or emails can be just as violative of the non-discrimination, non-harassment laws and policies as saying something to someone's face in person in the office. So making sure that your workplace conduct policies contemplate the teleworking environment is important. Setting policies or protocols regarding how the office or the workplace is going to operate in terms of limiting in-person meetings or gatherings, the use of communal areas, whether it be having a certain maximum or closing them off entirely, thinking about how employees will access food and drink in a way that it doesn't have them jammed up in a small space together. Thinking through policies on visitors and third parties in the workplace, if you have suppliers or channel partners that come on site, thinking through what you might require of them or who may be excluded or where they will be sent when someone shows up. Thinking through if you use staffing firms or third parties to supply temporary workers, making sure that you're on the same page with those third parties as to what the COVID-19 policies and protocols are, including, making sure that they're complying with the relevant guidance and regulations as well. I know I've already been talking for quite some time, so Rachel, I don't know if anyone has any questions or if Anthony, if you had anything to add.
I don't think we have any questions from the audience at this point, but I mean, I have a few questions. I mean, even just looking at all of these pieces of the puzzle, for smaller companies, and by that I mean the groups that are 25 to 50, this seems like so much effort. I mean, who are the right people? Probably, I know you mentioned the general types of people to be on this committee, but I mean, how is there any guidance on how smaller companies should go about getting people? Is it people doing extra work? Are you hiring new people? What's kind of the best scenarios here for those companies that aren't at the giant level of manufacturing or large offices, but still have to figure out how to get 25 to 50 people back to work?
Right. Yeah, it's a great question. And unfortunately, the answer that I've been seeing with clients, not unfortunately, but just the reality of it is that this is going to be someone who already wears several hats and now they wear the COVID-19 hat. So trying to equip that person with as much leeway in terms of their other duties, recognizing that for the next month, 2 months, 3 months, a good amount of their energy is going to be spent on navigating these issues and communicating with the workforce, because I typically am seeing someone in operations be the person that's, or even an office manager, depending on the level of authority they have taking this role, or someone even in the finance department, depending on the size of the company and the pressing business needs in terms of who has and I say extra time in air quotes, right, who has any capacity add this to their plate. I have not seen companies hiring someone externally, either as a consultant or a new employee, to address this, though. I would not be surprised if enterprising businesses start offering some sort of consultation. Also, if you use a company like TriNet or even the benefits administrators, they've all been exceedingly proactive in both in terms of supporting their clients and providing thought leadership and guidance to them. So that's another resource that smaller businesses can tap with respect to trying to get sample policies or sample protocols and updates, because it can certainly be overwhelming in terms of how quickly things are evolving, and having that flexibility built in and knowing that it's not going to be perfect. And we're certainly hopeful that these state and federal agencies will recognize that employers aren't going to get it perfect, right? Particularly
Right.
smaller employers.
Yeah, I'm really glad you mentioned TriNet. Actually, they are a partner of ours. So if anyone on the line has not worked with TriNet or would like some information, they do have a ton of information
Mm-hmm.
and guidance that they provided. And it's incredibly helpful. We're actually going to do a webinar with them closer to the end of the month about some of these topics. But
Oh,
I think
good.
that's a really great thing to bring up, that they're a good resource for the community. And I think I just want to echo to what you said about communication. As we've been having the conversation with our member companies and talking through the policies that they're putting in place, everyone is getting a bit of fatigue when it comes to all this,
Mm-hmm.
but communication is so crucial. And it comes down to culture as well, right? If we're all in this together, seems to be the message that a lot of folks are trying to convey in their companies and their firms, is this is not just for you, this is for the group as a whole. And we need to be kind of looking at it that way. I think we had another question from Brian. Brian, did you have a question?
Yeah, thanks, Rachel, and thanks, Anthony and Kate. This is great info. I have a question on just enforcement and the idea behind whistleblowers becoming a bigger threat.
Mm-hmm.
What should employers think about if they're going to get caught or get snagged on something? Is it more likely going to come from a whistleblower complaint, or is it going to come from sort of an enforcement from OSHA or some other enforcement body when it comes to kind of implementing these rules? And I know that PPP is definitely a whistleblower hotbed, but I mean,
Right.
Yeah.
I mean, I've heard law firms have, some, not saying the ones we're talking to, they have basically two different, PPP help and then PPP whistleblower enforcement.
Right. Yeah, it's a great question, Brian, and a couple of thoughts there. And I'll touch on this a bit with respect to thinking through not just the COVID-19 specific compliance, but also the corresponding compliance issues like non-discrimination. So bringing, where I see employers, and I'm going to touch on this a bit later, but where I predict employers getting tripped up here is less with the technical compliance of, do you have enough hand sanitizer, but more with respect to things like wage and hour compliance issues, paying employees for this, screening time, waiting for their temperatures to be taken or whatever it may be. Also discrimination issues with respect to employees saying that either ADA accommodations were not made or were made to one person and not to another person, or that the order in which employees were brought back to the office or brought back from furloughs was discriminatory. But with respect to whistleblowing and retaliation, as I said earlier, when I see and I litigate retaliation cases, including False Claims Act retaliation cases and other whistleblower cases. So unfortunately, I see it when it has gone completely off the rails. And oftentimes it's when the the employee or the former employee didn't feel like they had a channel to be heard and to be recognized with their concerns. And so that doesn't go away, that just goes underground, right? So if you, and going back to what I was just saying about having an open channel of communication, making sure that employees don't feel like their complaints or concerns are just going into the ether, or that they're poo-pooed when they raise concerns, even if in the middle of everything else the business is dealing with, the last thing you want to have to address is kind of a, you know, a disgruntled employee's concern about PPP or something like that. It is important to make sure they feel heard. In terms of compliance, I imagine that OSHA is going to be overwhelmed, and all of these agencies will be overwhelmed. So if it's you know, my employer doesn't have enough hand sanitizer, I think those will drop to the bottom of the priority list. The Mass AG's office does now have a complaint form, and they will be in charge of enforcing the COVID-19 safety standards. So I think it's also important to train the frontline employees, whether it be someone who opens the mail or accepts service of process, to understand that if you get something from the Mass AG's office that looks like it's some sort of complaint, to have it be funneled to the right, whether it be legal or ops or finance, to make sure it's going to someone and being addressed in a timely manner. And then, yes, with respect to the PPP, it is certainly going to be, because, and for anyone on the call who is blissfully not involved with any False Claims Act issues, what the False Claims Act prohibits is basically fraudulently using the government's money. It often happens in the context of Medicare fraud, or government contractor fraud, but here plaintiffs and False Claims Act plaintiff side attorneys are going to be taking a hard look at if an employer is taking PPP money and then not complying with the rules that Anthony went through at the outset of this presentation. So the difficult piece with False Claims Act retaliation cases or False Claims Act cases is that they're filed under seal. So an employer won't necessarily know for some time if they're being investigated for a False Claims Act case. But I think, Brian, to answer your immediate question, making sure that employees have a clear communication channel to raise complaints and concerns so that you get them before the AG's office or the federal agencies get it.
And it should be noted that the SBA committed to audits of any and all PPP recipients whose loans were over $2 million. So there's some proactive enforcement too. That you know, I don't know who that applies to on the phone, but they sort of used an arbitrary line at 2 million.
Mm-hmm. So, and speaking, Rachel, of information that's kind of overwhelming, the PTO and leave interplay now with the COVID-19 CARES Act, FFCRA legislation has created, you know, another layer of leave administration that employers have to deal with. And actually, the FFCRA leave is only available to employees that are employed by a company with 500 or less employees. So it actually is falling directly to smaller employers. So these leave laws have expanded. Currently, the FFCRA leaves are available through the end of the year. I don't know whether that's going to be changed as well, Anthony, in terms of extending that. But thinking about, in terms, setting aside the technical compliance with the new leave laws, a practical consideration as you're planning on your workforce coming back full-time or some capacity to the workplace. We've all been home, and as I noted earlier, people aren't really taking PTO, because if you have a medical appointment, for example, you can be gone for a few hours and then you're back online. No one's really the wiser. So there's a real risk. And if you operationally have certain times of the calendar year that have a high staffing need, thinking through how you're going to address and prevent a run-on PTO when everyone wants to take time off in September or October, or whenever it feels safer to take a vacation day and actually travel somewhere. And then just the morale issue of if we get to the end of the calendar year or close to it and employees really haven't been able to take meaningful vacations, thinking through how you might be creative with your PTO. So things like allowing a one-time carryover of PTO, even if you don't currently have a carryover of PTO, paying out some certain level of PTO. And I typically recommend, as most of you probably know on the phone, in Massachusetts, if you provide vacation, you have to pay it out upon the termination of employment, the accrued but unused vacation. So I typically recommend that employers don't allow carryover because it creates a larger financial accrual you have to have on the books. So this would be a one-time exception to, a carryover rule. So making sure that anything that you put in place, and Rachel, to your question on kind of having the infrastructure to have a whole suite of new policies, it doesn't have to be new formal policies, but if there's a communication around, for example, charging fewer days if someone uses PTO during a certain period of time, just having a clear written communication, even if it's an email with 3 bullet points that says, here's our PTO changes, this is a one-time exception, this otherwise doesn't impact our standard sick leave or vacation time policy, should be enough to make it clear to employees that this is not changing the PTO policy moving forward. Okay, and I've previewed a bit of this, but talking through some of the potential liability issues here and employee rights and protections. So as I noted, I think an active area for employers and for potential disputes and potential litigation, and really just the challenges here are ADA accommodations. Now the ADA is the federal anti-discrimination law protecting qualified disabilities. It only applies to employers with 50 or more employees, but the state laws here in Massachusetts, Chapter 151B is the anti-discrimination statute, and that applies to employers with 8 or more employees. So it's, even if you're not technically bound by the ADA, there's still potential exposure here. So with respect to accommodations, this is going to be a tricky one for employers because the ADA covers both physical and mental disabilities, and you can certainly ask for medical documentation, but given that hospitals and healthcare facilities are operating in a different manner than they were in normal times, you will likely have to build in a bit more flexibility. For example, if an employee can't get in to see their doctor, or a doctor's not completing the required paperwork in time. So there will be some patience and flexibility that will be needed. Another challenge is with respect to employees that have been teleworking and now they want to continue teleworking. And we've already had clients with employees that come right out and say, I just like teleworking better, which that's a bit of an easier case because you can level set that this was a temporary accommodation that the whole workforce or part of the workforce was eligible for given the pandemic, but the expectation moving forward is that people work from the office or from the facility. But if an employee comes to you and says, I want to keep working from home because I'm having severe anxiety, I don't want to get on the train, I'm afraid to go in public, then that's getting into an area that might be protected with respect to a qualified disability. So you should kind of hit pause, try to either engage internal counsel or outside counsel, or someone experienced in HR to have that conversation with the employee about what type of reasonable accommodation might be possible with respect to having a temporary work from home or a trial basis, and being mindful of precedent setting. So if you let one person, because of anxiety, keep working from home, you have to be prepared for allowing other employees. So being mindful of taking a consistent approach. And I know we're getting short on time here. So I've already run through my concerns on issue spotting on discrimination and retaliation. Just like a decision to terminate an employee or to discipline an employee, a decision around bringing an employee back from furlough or back from remote working to working in the office should also be based on legitimate, non-discriminatory, non-retaliatory reasons. And again, a refresher on your policies and any trainings is always helpful here with respect to reminding your workforce of the expectations and training your managers on these issues. We've touched base on OSHA, I'll skip that. On wage and
Yeah, my audio stopped.
Yeah, it looks like Kate's internet froze. Rachel, do you see that?
Sadly, I do. Yes, I'm not hearing or seeing Kate anything.
Here, let me try to reach her. Hold on.
Otherwise, you're gonna have to wrap it
Oh.
up, Anthony.
I was gonna say,
Yeah.
internet. Doing so well for 54 minutes.
I know.
all right, am I back online here?
You
Oh,
are.
you got it. Yes.
Okay.
Right.
That was a good run there, huh? With no technical difficulties. So I'm not sure where I froze, and hopefully I didn't freeze in a terrible facial expression or anything. But
You were right at wage and hour, right at the top of this slide.
okay, so with respect to if you have a non-exempt workforce, meaning a part of your workforce that is paid hourly and is eligible for overtime, it's important to be mindful of whether you're having them record time and be paid for extra time that it takes. For example, if you're doing temperature scanning, or if you're having them fill out questionnaires or put on certain safety equipment at the start of a shift, then it's still a bit unsettled as to whether which time should be paid for, but it's really de minimis, right? It's a couple minutes at the start of a shift and at the end of a shift. So the safest bet is to assume that all should be working time and that they're paid for that time. So if they start their day at 8:55 because they have to wait in line for temperature scanning, then that time should go on the clock, so to speak. Making sure with respect to teleworking that employees are tracking time if they're non-exempt employees that continue to work remotely. As I noted, having trainings, even if it's just having this as an agenda item at your manager meetings to make sure that everyone's feeling comfortable about the policies and protocols, and making sure that your managers understand what your COVID-19 response or plan of action is, and making sure that they understand where to funnel employee concerns. Okay, so this last slide just references some of our resources here at MINTS and ML Strategies. So I know I didn't leave much time for questions and I covered a lot of territory, but happy to answer any other questions.
Let's see. Any questions? Feel free to pop them in the chat bot. I think someone made the comment that, you know, companies with multiple locations, you know, are gonna have to ensure that every location has the same process. You know, I'm curious how the states differ. So if a company has headquarters in one location, but then other locations have different state regulations, are they all kind of looking about the same, or?
So I wish I could say yes. Generally speaking, they are. But for example, if you have operations in New York or New York City, I recommend you just pull out of that state. I'm just kidding. You know, that's you know, the usual suspects with having more onerous regulations for employers are New York, Massachusetts, California, Chicago, Illinois, DC. So for example, a lot of times where there are differentials are not so much around the general safety guidelines, but more around leave entitlements. So New York and New York City and New York State have some different leave entitlements than other states do. So what we recommend typically, depending on how many employees you have across state lines, is if it's feasible, use the most expansive or the most generous state policy as your floor, or if that's going to create too much additional cost that's not necessary in your other states, having a general policy, a general framework, and then having some state specific addendum or policies that only apply to those employees. And that's where your benefits provider, your Trinets of the world, or even your payroll providers can also help navigate those in addition to counsel.
Okay, that's good. That's good input. Anthony, quick question.
Yeah.
It's probably not a quick question,
No.
but you know, we're seeing a lot. I've been seeing a lot of the news about, hey, there's all of this money in the PPP funds, and people are not actually accessing it.
Yeah.
Is that because there's a lot of fear still around the guidance?
I think it's less about the guidance and more about public perception. You know, there are eligible entities like the Los Angeles Lakers or like Shake Shack who gave the money back because because of the, you know, first of all, you're open to an audit now automatically over 2 million, but also the public perception toll has been not good. So I think that there's been a lot of that. I think the guidance is now basically clear and clear enough that people are understanding. What's interesting is, you know, a lot of industries need more help. So despite the fact that there's money sitting in PPP, if you've already got a loan, you can't go and get another one. So we are now in the throes of, you know, what mechanism comes next. It doesn't look like it's going to be PPP again, but there is growing bipartisan agreement that more business support needs to happen, whether it's paycheck support in particular, or whether it's revenue based or operating expense based, you know, that remains to be seen. I will go back to that first question about the definition of utilities. On the application, as I put in the chat bot, is the first time the utilities are listed out without et cetera at the end. So we saw it in initial guidance and elsewhere with Rob, with you know, a few examples and then ETC, and so that was a little bit unclear. So we are taking the application to be the definitive list because it ends in a period. There is some ambiguity about what transportation means in terms of a utility, but I think the prevailing wisdom is if there are transportation costs that are typically tax deductible, those would qualify. But everything else is pretty straightforward: internet access, gas, water, electricity.
thank you for clarifying that. And since we're right up on time, and I know people are getting back to other calls, Kate, Anthony, thank you so much for this incredibly informative session. I think it was really helpful. Obviously, there's a ton of information and a kind of a scenario of ways that you could go about doing this. Are the slides that you presented today, can we share those with the crew in a follow-up email?
Sure.
Great. Okay. I'd love to get those. I think they're going to be really helpful for a lot of our members, especially ones who weren't able to join. But thank you both so much for joining us. And thanks everyone for signing on. I think this was really great.
It's our pleasure. Thank you.
Yeah, thank you for hosting.
Absolutely. Everyone have a wonderful day. We'll talk soon.
Yeah, you too. Be careful out there.
Okay. Yeah. Bye-bye.
Take care.